we have been making a general, error in saying that once the Supreme Court has jurisdiction to interpret the Constitution, then no matter how it happens, it has to. But that is not what the authorities tell us. The authorities have told us from way back in 1970, when Bedema was decided, through Edusei, J.H. Mensah, and all the other cases, that there are situations where the Constitution carves out a part of the enforcement of the Constitution to other courts. One of such situations is when there is a human rights issue, you go to the High Court as original jurisdiction. Another is when there is an election petition, you go to the High Court for election petition. In all the cases where the Supreme Court decided that you can come to the Supreme Court to challenge a person's membership of Parliament, are situations where there is a violation beyond the electoral practices. There's a violation of the Constitution itself. So the fact that some cases on questions of challenging the election of a member of Parliament, which originally is reserved for the High Court, the fact that such questions have been decided by the Supreme Court, there's a principle. If you read the cases, it is only when the Supreme Court comes to the conclusion that the continuing sitting of the person in Parliament is a violation of the Constitution itself, and those ones come under eligibility, criteria, whether the person is a dual citizen, whether the person is a member of a particular constituency, and all that. Those were cases that were decided on that. So we should not confuse the situation of the fact that there's an interpretation question, then therefore we have to go to the Supreme Court. No, it doesn't work that way. Let me tell you, when interpretation itself is not a substantive jurisdiction, a court must first have a jurisdiction to enforce the law. It is when the court is about to enforce the law and there's a question of interpretation, then the court will do the interpretation. So no one actually goes to court, because the common law tradition, no one goes to court to just ask a question whether or not this is true and then goes back home. It is not allowed. That is what we call advisory opinion or a declarative judgment. And in the common law, that is not allowed. And in our Constitution in particular, the Supreme Court has said over and over again that we are not a dictionary. You don't just come to us and ask the question, what is the meaning of this? And then you get the answer and you go home. No. You must show us that we need to give you a specific relief. And if you read all the cases that have passed, there is nowhere that the Supreme Court will just give a declaration and then goes to sleep. It goes on, and that is because when you read Article 2:2, 2:1 says that the Supreme Court has the power to enforce the Constitution, and then when someone alleges that. Then when it comes to 2, it says, the Supreme Court shall, based on the declaration made, shall make orders and directions. So the Supreme Court doesn't have the jurisdiction to just give an opinion as to what the meaning of a law is and then leave it there. That is the first error which you can see from this decision, that the court basically just said, this is the meaning of Article 97 and gave no orders.